Hello, welcome to our next lecture. We are closing in on the end of the semester. Hopefully it's been a great journey thus far as I've looked at these landmark Supreme Court cases, learned how to read these opinions, wrestle with the concepts presented by the court and by the competing sides. We are now at another First Amendment case, another landmark case regarding prayer in schools. So Engel v. Vitale, I believe is how you say it, is our next case. You can see that we are situated here in 1962, a very interesting period of time for our country's history. Several reasons. The civil rights movement, of course, is going on. Feminism is taking root. We have the Vietnam War occurring. There is a lot of turmoil perhaps across the world, and it's starting to see itself in a variety of ways within our country. So one of those ways is, of course, praying in school, whether prayer in school violates the Establishment Clause of the First Amendment. So we'll dig into this case. We're going to look at the majority opinion, the concurring opinion, and the dissenting opinion as well. Hopefully by this time, at this point, I'm publishing a article on this case as well as a couple other cases that deal with more or less religious practices within the public school and how the Supreme Court, more or less eroded a lot of the religious practices, or depending on how you look at it, religious freedoms that come within the bounds of public school. So we'll jump into this case. I think it's appropriate to start with the prayer that's actually at issue. So I believe it's 22 words. I think the opinion covered that. But we're looking at this here. Almighty God, we acknowledge our dependence upon Thee, and we beg Thy blessings upon us, our parents, our teachers, and our country. So this prayer was recited by teachers in this public school each morning. That's how they basically began their day, was with the teachers reciting this prayer. The students would join in, or if they didn't want to, which will be of particular importance, they were not compelled. They were not required to. They could simply remain silent, or they could step out of the classroom and come back in. Again, I think it's worth acknowledging that this isn't a doctrinal issue. This isn't any sort of class. This isn't a subject being taught. This is, I think it was actually, is it this case or maybe another case, set alongside like the announcements and the Pledge of Allegiance. Just a very rudimentary way to begin the class. You may have a catechism in some of your classes of how you start the day. There's some sort of cadence that your teacher used to sort of acknowledge that we're going from chaos that comes with starting a new class or in between classes to beginning lecture time or whatever your school does or program does to basically differentiate between non-class time and class time. And at this period of time in this school, it was this 22-word prayer that ultimately helped begin the day. Like I said, alongside announcements, I believe, or maybe the Pledge of Allegiance as well. But it was just a recited prayer, I think, that the teachers led. And now that is the subject of our discussion in this case. So taxpayers and parents, concerned parents, and some students challenged this practice as a violation of the First Amendment. So again, always important, go back to the text, go back to the First Amendment in the Constitution. Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof. So we're looking at the free exercise clause in part, but more importantly, we're looking at that establishment clause, that Congress shall make no law respecting an establishment of religion. I believe it was our last case. We dealt with the concept of the Bill of Rights being applied to the states through the 14th Amendment. So that's a important concept to know. For our purposes, though, you may see Congress, and that question may have come up last week or 2 weeks ago, whenever it was that we went over this, the case. I believe it was the Everson case, but I could be mistaken there. The 14th Amendment is used as basically a vehicle to get the Bill of Rights applied to the states. So in other words, the states must respect the rights included in the Bill of Rights. So in other words, you could read it as saying, states shall make no law respecting an establishment of religion. Public school, of course, is a branch or an agency or at least an extension of state government. And so by virtue of having a school, public school, requiring or at least causing to be required, this prayer, the argument that the petitioners make is essentially this prayer violates the First Amendment. So they have protection from the government. These people complaining of this prayer, they have protection from the government to ensure that the government, or in this case the school, public school, is not establishing a religion. Shall make no law respecting an establishment of religion. So, may seem foreign, but let's just sort of unravel that a little bit more. Teacher gets up, beginning of each day, Almighty God, we acknowledge our dependence upon Thee, and we beg Thy blessings upon us, our parents, our teachers, and our country. Said every day, students would say this prayer alongside the teacher, or they could remain silent, or they could leave the room. It wasn't like the students had to say it, and if not, they were disciplined. Again, this wasn't like a Bible class or a class on theology or a big banner saying we are Christians or whatever else it may be. And anyone that's not, we're going to oppress or we're going to beat up or whatever else it may be. This is quite literally the prayer. It's of course printed in the opinion, and that's the dispute. So by virtue of the public school, an offshoot of the government, requiring more or less, that's a contentious point, this prayer to be recited every day, the argument goes that it violates these people's First Amendment right to be protected from any law respecting the establishment of religion. And of course, going back to Marbury v. Madison, if a law is deemed unconstitutional in that it violates the Constitution, or of course an amendment to the Constitution, then that law will be struck down because Constitution will trump any other piece of legislation. So in this case, our attention now, our competing interest, is basically asking the question whether this prayer violates the First Amendment, again, through the 14th Amendment. The court ultimately holds that it does, right? The court looks at it and says, yep, this prayer violates the Establishment Clause. The government, acting through the public school, cannot compose these official prayers and carry out the said prayers as though an extension or an offshoot of the government. So, okay, that's our holding. They get to it pretty quick. It's a relatively short opinion, and the court sort of dives into the analysis as to why that's the case. Right? We have the issue before us, whether this prayer or this law, basically requiring this prayer, violates the First Amendment. The court says that it does. It does violate the Establishment Clause of the First Amendment. So this law is going to be struck down. And so then the court gets into why, right? Why is that the case? Why is it important to have the Establishment Clause in the first place? So there's two main purposes here that the court looks at and considers. One is the to prevent the destruction of government and the degradation of religion. They basically put this concept together that anytime you have okay, sorry about that. I'm not sure exactly where that train of thought got derailed, but we're talking about the purpose of the Establishment Clause. Yes, so combination, right? The combination is what the court's looking at. They're looking at kind of a historical analysis of when religious oppression has occurred, really at the hands of government. So looking at just a little bit of our history, the country's history, certain groups fleeing what they considered to be religious oppression, and that was at the forefront of their minds. Is anytime you have the government, right, enforcing a certain religion, bad news bears, right? It just doesn't work out well, creates sort of a divisive force, and ultimately is worth protecting and is separating, right? We looked at where does this concept of the separation between church and state come from? Is it truly a two-sided approach, namely that you cannot have any sort of influence from the church to the state as well as from the state to the church? Or is it truly set up in a way where we're just worried about the government? We're just worried about the state influencing or supporting or controlling religion, basically forcing a certain religious belief upon the people. So the majority opinion looks at it and just says, look, anytime that you combine the two, government and religious practices, there's two big reasons why we do not want that establishment clause. We want the establishment clause because we want to ultimately prevent the destruction of government and the degradation of religion. We want our government to be the government, and we want our religion to be a religion. We do not want our government to be the religion, and we don't want our religion to be the government. That's a pretty good argument, I think. That's a pretty good reason as to keep them separate. Better yet, though, the second reason they give is that any time, in theory, you've had a state-sponsored religion, it inevitably leads to religious persecution. Why? You looked at who's actually in power, who's actually running the government, who's actually in charge, and if they're of a particular majority, of course, then any sort of minority, any sort of minor sect, perhaps, or religious denomination, or a completely different religion is going to be persecuted. Now, is this true, right? Is this right? Is this a good way to think about what religious persecution is? I think it's worth inquiring as to what religion is, right? If we don't know how to define religion, how are we supposed to know when to separate the two? So let's kind of rewind real quick, okay? Hopefully that thought is just parked right there at the front of your mind, and we're going to think about this. We're dealing with 1962, okay? In this opinion, we are arguably still considered a somewhat culturally Christian nation. It's a pretty bold claim. I'm sure there's a lot of competition for that claim as to whether it's true or false. Let's just take it as true. Let's just take it as true that there are certain structures in place within our society, again, across the board, right, writ large. Everyone has a certain understanding of Christian principles and morality, and they have a certain level of biblical literacy. If we take that as true, then the court's opinion actually makes a little bit more sense. The majority opinion here starts to, it clicks, I think, in a way where, oh yeah, if we have a certain, let's just say, denomination of Christian in power in the government, and they start enforcing certain parameters along those lines of their religious beliefs, then what is that to do for other sects or denominations of Christians? Okay, well, that's an interesting question, right? If it's all Catholics, let's just pick on Catholics, for example, because I'll pick on Baptist here in a second. If it's all Catholics in Congress and they're passing laws that are looking more like they're respecting the doctrines of Catholicism in the Catholic Church, then Baptists may very well feel like we're having our liberties, right, our civil liberties, infringed upon. We're being persecuted. And Baptists, may very well wave the constitutional flag and say, no. We have protections guaranteed by the First Amendment such that government and church are separated. And that is ultimately the analysis. They go all the way back again to the Jefferson and Madison conversations, Madison's memorial and remonstrance against religious assessments that we looked at in Everson v. Board of Education, to look at this concept of any sort of incremental progress or inclination towards state-sponsored or state-ordained or state-sanctioned religion has the capability, the potential to bust open the doors, right? All of a sudden, there's going to be just a overwhelming sense of persecution for these other beliefs. But we're situated in 1962. We're not in modern day. So it's worth teasing out, I think, just a little bit more to hopefully make this point and land. But maybe even go back and reread the case after this lecture and kind of put on this lens. There's a sort of implicit understanding of Christian doctrine within the court's opinion, I believe. There's a certain understanding of what religion is, namely in the Christian faith and the Christian religion, that the court is worried about. So, in other words, it's not a completely abstracted, far-reaching religion under, saying basically it's a religion, but, there's only 12, practitioners, or there's only 1,200 practitioners across the world. This is a fairly well-established principle within our country, our nation, our society at this point, as to what sort of foundational moral principles our country is standing on. And they just so happen to be Christian, I would say, leaning, or at least relatively similar to what we would call Christian belief. Again, let's just go back to the prayer. Almighty God, we acknowledge our dependence upon Thee, and we beg Thy blessings upon us, our parents, our teachers, and our country. I would argue, or perhaps at least question, what sort of religious dogma is being perpetuated by this prayer. What sort of religion is being established or respected by virtue of this prayer? It's theistic, right? We can take that as the first principle, Almighty God. So acknowledging God, we acknowledge our dependence upon Thee. We'll get to this in here in a bit, but one nation under God, we acknowledge our dependence upon Thee, and we beg Thy blessings upon us, our parents, our teachers, and our country. As though, again, a kind of a supposition there that God bestows blessings. And we can acknowledge our dependence upon Him and ask, nay, beg, beg Thy blessings upon us, our parents, our teachers, and our country. So, maybe it's bringing some thoughts to the foreground. Hopefully, during the reflection questions and assignment for this week, you'll be able to wrestle with these a little bit more. But I want to encourage you, just keep that in mind. What religion are they talking about here? It's, again, almost like they're presupposing this is Christian, and we don't want to enforce Christian beliefs onto atheists or agnostic, or at least just unbelievers. So we have the First Amendment. If there's going to be sex within a given religion like Christianity, again, Catholics to Baptist, then, okay, that can kind of make sense. But if we're stating on moral principles, and it's across the board, it's across the nation, we're going to generally agree as a nation that these are the moral principles we're going to hold true and dear, and otherwise want to instill and cultivate into our children, into our society via education, then how is that respecting the establishment of religion? Isn't that just helping our society flourish by cultivating good virtue within our population, within our young people, within students via education? The court doesn't see it that way. At least the majority opinion doesn't see it that way. They see this prayer as a textbook case, perhaps, of establishing religion. And I think what they have in mind is the Christian religion, right? They see this, they read this, they probably themselves have been educated and know certain foundational Christian beliefs, or at least Christian doctrine to an extent, to read this and think that is respecting the establishment of religion. So let me put it another way. What's the argument that this is not a religious sentiment, that this is not respecting the establishment of religion, that this actually, in fact, has nothing to do with religion, but could very well just be a good principle, a good moral belief? And if it's just a good moral belief, does that violate the Establishment Clause of the First Amendment? Worth considering. Okay. So, where are we? Yes, let me read this part in the opinion. So we talked about the two different purposes. So this is again from Madison. It is proper to take alarm at the first experiment on our liberties. Who does not see the same authority which can establish Christianity in exclusion of all other religions may establish with the same ease any particular sect of Christians in exclusion of all other sects? Again, Catholics, Baptists, Presbyterians, Methodists. If one group has the power, and they had that power by virtue of being able to establish Christianity as the main religion, then what's to keep certain denominations or groups from vying for that power? That the same authority which can force a citizen to contribute 3 pence only of his property for the support of any one establishment may force him to conform to any other establishment in all cases whatsoever. So I'd like to think of this as a might makes right argument. If you're in power, you get to decide what the right religion is. The other way to look at this too, if you know the book, if you give a mouse a cookie, it's, I think, an apt example here, an apt analogy. If you give just a little bit, how much more are they going to take? You provide an inch, they take a mile. That sort of concept, I think, is really what's going on in the back of the majority opinion's mind, but they're relying on Madison's argument in that memorial to decide or to determine why this is the right opinion. So, on one hand, is this a religious prayer? Is this respecting the establishment of religion? And if so, then yeah, probably sure, it follows that we need to protect our First Amendment rights, but what if this is just good moral principle? This has nothing to do with Christian doctrine. This isn't a matter of a certain denomination within Christianity. Then what do we do with the majority's opinion? I'm so glad you asked. It's a great question, because that is ultimately what the concurring opinion is looking at. When we have a concurring opinion, I don't know if I've explained this before. Concurring opinions are largely what they literally mean. They concur with the ultimate holding, but they have usually a little bit more to say, or they wouldn't say as much, or they have a different way of getting to the holding. So they side with the majority. They're like, yep, we got the right result, but how we got there is not the way I would have gotten there. So Justice Douglas's concurring opinion, he points out that students are not compelled to recite the prayer. Very important. They can, in fact, leave the classroom or remain silent. It's only the teachers are the ones that recite the prayer. And here's the thing. The teachers aren't complaining. The teachers aren't bringing this lawsuit and challenging this on constitutional grounds. It's simply the students and some aggrieved parents and taxpayers that are ultimately challenging this law. Again, the law that's saying that requires, or otherwise, I'm okay with that, requires this prayer to be said each morning. So Justice Douglas points out that what the school does with this prayer, namely at the beginning of the day, again, kind of separating we're not in class to we're in class, or the day has not yet began and now it is beginning, that sort of cadence is what a lot of institutions do namely like the Supreme Court does. He has this quote in here. I think he calls it the crier of the court. Yep. Only a bare fraction of the teacher's time is given to reciting this short 22-word prayer, about the same amount of time that our crier, like announcer, bailiff, kind of person that helps enforce the ordering of the court, spends announcing the opening of our sessions and offering a prayer for this court. Yet, for me, the principle is the same, no matter how briefly the prayer is said, for in each of the instances, given the person praying in public, or given the person praying is a public official on public payroll. So he sees it as same. There's like a slight hypocrisy here of, wait a second, guys, like we're saying that this is the establishment of religion, but we do the same thing. Are we gonna have to sue ourselves, basically, right? Are we going to have to promulgate this lawsuit to point out our practices that involve saying a prayer, acknowledging the Almighty God, and thanking Him for blessings? It's worth pointing out, right? It's worth questioning. So he looks at their pay, looks at the amount of time they spend. Again, this isn't a whole class. This isn't a whole semester. This is 22 words that are said at the beginning of each day. It's not discussed. It's not, there's no kind of pontification about what the meaning of this prayer is. The prayer is simply stated. And then the class moves on. The day moves on, and that's it. So I think the bulk then of the majority's opinion, or the concurring opinion, is that there is not coercion. So in other words, the school is not forcing the church or the establishment of religion, this prayer, onto the students. The students ultimately have the freedom to remain silent, to not practice in that belief, or better yet, just leave the classroom. And so it's as though they were never subjected to this prayer anyway, in the first place. So all that to be said, he's okay with where it lands, as we'll get to in a second, namely that it does violate the Establishment Clause, but he thinks it's important to point out that there's not necessarily coercion here. We're not respecting the establishment of religion, and it's an important point to sort of draw out. The students can, in fact, remain silent, and if they want to leave the classroom, they can. But otherwise, the school itself is, again, a function of the government is not forcing or coercing certain religious practices or dogma onto the students. Okay, but he points out, again, in the Everson v. Board of Education holding precedent, that any sort of incremental increase in establishing any sort of governmental, ordained, or sanctioned religion would overwhelm the need to have separation between the two. So again, sort of the concept of, if you give an inch, they take a mile. If you give a mouse a cookie, he's going to want milk. So we have to do everything we can to keep separation between government and religion. So yes, there's no coercion here. There's no force that takes place with regard to this prayer with these students. It's not you go to the principal's office or you get suspended if you don't say the prayer. It's just, hey, we say the prayer. That's just what we do. It's part of our cadence every morning. No big deal. If you want to remain silent, you want to remain silent. If you want to leave the classroom, you want to leave go for it. But any sort of incremental increase, any sort of tendency towards government-sponsored or government-ordained or government-established religion teeters that line too much. There's too much of a risk of what could happen from there. Okay, moving on to the dissent. So, kind of gave this away earlier, but hopefully it works now. Justice Stewart's dissent points out all of these things that we have in our society as a nation that acknowledge God. Okay? When the court begins its procession, we talked about that. When Congress begins its session and prayer is said, every president, starting with George Washington, the very first president, was sworn in, acknowledging his dependence on God and asking for his protection and help. Our national anthem, right? Hopefully you can hear that right now. Our national anthem also acknowledges God, one of its verses. In God is our trust. Our Pledge of Allegiance, right? One nation under God. Here is our currency at the back of whatever bill this is, or coins, whatever else may be. In God we trust. When we're sworn in, when we are upholding the prerogative, perhaps, to abide by law and order and fundamental concepts in law, we're swearing people in to tell the truth, all truth, so help them God. Right? Here's the Bible that we swear upon. And again, you look at any sort of institution, perhaps prior to a certain year in the 21st century, national anthems played, people are standing up, right? Hand over the heart. There's a national day of prayer established. The list could probably keep going on and on and on, and it probably does in the footnotes. But suffice it to say, we are a nation that recognizes a supreme being, our reliance upon God. And so to misunderstand this principle is really to throw out our entire concept of who we are as a nation. Good quote here. With all respect, I think the court has misapplied a great constitutional principle. I cannot see how an official religion is established by letting those who want to say a prayer say it. On the contrary, I think that to deny the wish of these children to join in reciting this prayer is to deny them the opportunity of sharing in the spiritual heritage of our nation. And he quotes this other Supreme Court case here that states, the Supreme Court of the United States of America states that we are a religious people whose institutions presuppose a supreme being. Okay. So, a lot to unpack there in a very short period of time. But I think there's merit to this point, and it's worth considering deeper than just the dissenting opinion side of things. Justice Stewart is looking across our nation, looking at certain traditional, our heritage. Where have we come from? What is sort of the air that we breathe? How do we operate as a nation? What is our culture, right? What is our paideia? What does it look like from an outsider perspective, perhaps, such that they would point out certain institutions or traditions or heritage that we would say, oh yeah, well, I guess we do kind of do that thing, right? I guess we do kind of stand up and put our hand over our heart. And we all kind of know the Pledge of Allegiance. And we do have money that says, in God we trust. And we do acknowledge that there is certain authority by recognizing God and help and begging for his help and blessings and in all facets of our life, not least of which would be our courts and Congress, and when we have a president or other leaders of our country sworn in. So he's looking across the board and he's thinking about this and saying, wait a second, the children have the right to acknowledge that spiritual heritage within our country. So in other words, you can't divorce the two. You can't say we have a nation or national history separate from our reliance on our Creator, on our supreme being. They were endowed by their Creator, right, with certain unalienable rights, that among these were life, liberty, and the pursuit of happiness. Right? Where does that concept come from, if not from a certain baseline? Throw religion out the window. Let's just think about this on moral grounds real quick, on philosophical grounds. Our country was founded, again, just quoted the Declaration of Independence there, founded on the principle that we are endowed by our Creator with certain inalienable rights. So God has given man certain rights that ought to be protected by government. So government should be established by the consent of the people, of the governed. So the government is acting outside of the people's interests. They have ceased to be legitimate government. So where do you see this show up? Right? Where do we see this concept of acknowledging our reliance upon our supreme a supreme being, our Creator, the Almighty God? We see it in all our institutions, right? We see it in the air that we breathe as Americans. And it's been that way, again, from the very beginning. George Washington being the first president of the United States had to be sworn in and ask God for his protection and ask for his help as he led the United States. So our currency, our lawmakers acknowledge God, even our witnesses within the legal system all acknowledge God. In the dissent here, Justice Stewart's going to make the point that this is just a spiritual legacy. That's a spiritual heritage. Why deprive children of the opportunity to simply acknowledge that spiritual heritage? Not get into it, right? Not necessarily study it or argue perhaps or teach or whatever else do to tease out these concepts, but just to acknowledge it. Justice Stewart says that's a right. That's a right that the children have. I think that to deny the wish of these school children to join in reciting this prayer is to deny them the opportunity of sharing the spiritual heritage of our nation. So is it patriotic, right? Or is it religious? It's worth asking, right? That's kind of the next point here. Final point, and really what we're going to get into with our discussion questions for this week, is where do we draw the line for religion? Is religion the same thing as patriotism? Here's another question. If any other flag is flown above government buildings that is not the flag of the United States of America or a recognized state within the Union, is that government respecting the establishment of a religion? What is religion? That's what it comes down to, I think. When we think about these concepts, it's important to start defining these terms. So, yes, we know we know when we see it. I think this opinion, and maybe even Everson pointed out, look, if all of a sudden the United States federal government starts building buildings and calling it the Church of the United States, yeah, that's it, right? Like, we can point to that and say, yep, that is why we have the First Amendment. Not going to respect the establishment of a state-sanctioned religion. Not going to do it. We're going to draw the line hard and fast. We know it when we see it. So then what do we do with this concept of just simply acknowledging our spiritual heritage? Because you can't deny that, right? You can't deny that God has been within the purview of our country from its very beginning. Now, is it a Christian belief, right? Are there Christian doctrines? Arguably, yes. Other people will probably say no. But can we deny that at least the theistic conception of God has been present? Okay. I would say yes, right? Go back to this lovely slide here. Ooh. This lovely slide with all the examples. Right, you look at our culture from a outsider perspective. You see our institutions, and we've acknowledged God at every turn from its very beginning. It's only a very recent turn of events in which we start saying that actually, when we say Almighty God, we thank Thee, right? We thank You for the providence that You've shared. We go back to the prayer, so we can end on that slide. When we start acknowledging our dependence on Thee and beg for God's blessings on our lives, for our parents, our teachers, our country, is that religious? Or is that just our spiritual heritage? Right? Is that just kind of a fundamental moral belief? In other words, we would go back to sort of a natural law principle as acknowledging our Creator, the first principle of law, right? Is that a bedrock assumption? The article that I mentioned earlier, I'll post that to our class page, or at least email it out, and I get into that. I think it's worth pointing out to those other cases if you're interested in these questions. But it depends on how you define religion. If religion is sort of this presupposed concept of Christian doctrine, then it's easy to tag this prayer up there and say, yep, see, religious, and strike it down. But if you approach it from another angle and you say, well, wait a second, here's our courts, here's Congress, here's our president, here's other leaders and officials, here is the national anthem, here's the Pledge of Allegiance, here's our currency. And we're all basically acknowledging this same concept there, but no one would say that that was the government violating the First Amendment until 1962. So there's been other cases that have dealt more or less with this issue. Of course, we looked at Everson last week or the week before and questioned, where is that line drawn? When does the government in fact establish religion? Are there certain neutral principles that can be applied such that there isn't any sort of violation of the First Amendment? But for this case in particular, it's worth thinking about. If this is in fact religion, then what else could be religion? Right? What else could be defined as religion such that the government is currently respecting the establishment of? And if that's the case, then our constitutional liberties as God-fearing Christians being infringed upon. Worth considering. So that's it for today. Got a little extra time to hopefully have a good conversation, get started on the questions or whatever else it may be. But in the meantime, pray that you have a blessed week. Hope this has been a great semester so far. Hope that you are still sending questions. Hope there's not just a sort of autopilot going on. Hope you're still digging into these cases, thinking through these concepts. You'll notice too that I'm requiring a lot more work on your part to actually parse through the cases, but I have full faith and confidence that you're able to work with these concepts more without so much hand-holding or underlining or whatever else may be in the cases. But as always, please email me with any questions you have, any kind of feedback as well. The slides or the cases themselves, the length of the lectures, whatever it may be, feedback is always appreciated. And until next time, I hope you have a great week. We'll see you then.